Welcome back. If there's someone who's having a terrible December, it's Shamila Batohi. Forget December, I think her entire 2025 has been a complete disaster. And today, I've got another bomb for you. In this video, you're going to see the moment Ngcukaitobi tells Batohi straight to her face, "You lied in your evidence." Not, "Maybe you made a mistake." No, he said, "You lied." Then watch how he catches her in a trap. Batohi claims Dr. Brauton never gave an opinion about the Mduli case. But Ngcukaitobi pulls out the documents and shows everyone that Brauton actually wrote pages and pages about it. The woman is caught red-handed. And the best part? There's this missing document called Annexure L. It was supposed to be attached to her papers, but somehow it disappeared. Ngcukaitobi asks her where it is, and she starts giving excuses about her team forgetting to upload it. My friend, how do you forget evidence at a commission? You'll see Batohi sweating, repeating over and over, "I didn't lie, I have no reason to lie." But when someone has to keep saying they're not lying, you know exactly what's happening. This is brutal. Ngcukaitobi is not here to play games. So hit that like button. It's free of charge. Yes, completely free. Subscribe to the channel. Now let's not waste time, otherwise you might be next at Madlanga explaining yourself. Let's go.
I still want to stick to the fact that you say Dr. Brauton did not deal with the Mduli matter. We've looked at the opinions. Do you accept that Dr. Brauton did deal with the Mduli matter?
I would like to explain what I meant when I said he did not deal with the matter.
I'm not asking you that question. Don't answer your own questions. Do you accept that Dr. Brauton did deal with the Mduli matter?
He addressed it in his affidavit.
Again, you're not answering my question. You are putting your own statements. Do you accept that Dr. Brauton did deal with the Mduli matter?
He addressed it in his affidavit.
Yes,
I would like
addressing
to
it.
explain what I meant by he did not deal with the matter.
Advocate Batohi, just answer my questions. Don't ask your own questions for yourself. When addressing the matter, that was dealing with the Mduli matter.
Not in my opinion, not in my view.
Yes. Thank you. I think the facts are clear for anyone to read. Could we then move on to the next topic?
Yes, Counsel. Reference is made to the transcript.
That's correct.
And I don't want to belabor this point, but I'd like to understand what you mean in answering the question by Counsel, because we have the transcript here. The very transcript that we are going to have to rely upon when we write the report. And I just need clarity. From the answer that you gave when I asked you questions, when you testified in chief, referring to that page 131 that has been made available to us of the transcript, where you answered the question saying, it is Dr. Brauton had not expressed a view. The words, had not expressed a view. What should we understand that to mean in relation to the Mduli matter?
Thank you, Chairperson, for giving me an opportunity to explain this. I think it's really important that I do. If we go to Dr. Brauton's affidavit again, where I was referred to earlier on, various parts of it, I have not been. If we go to LO00163, I mean, firstly, I want to make it clear, as I've said, that I have these affidavits. I have his opinions. It's clear that there's a part of it relating to the Mduli matter that's included. But when I said he did not deal with the matter, this is what I meant by it. If you look at paragraph...
He did not express a view. That's what you say.
Chairperson, if you look at my understanding of paragraph 45 this is at LO 00163, paragraph 45.
Is that the analysis part?
That is correct, Chairperson.
Yes.
Chairperson, he says, in light of the findings of the SCA full decision as referred to above, no recommendation is made that a section 12(6) inquiry be instituted. My understanding of that is that he was not making a recommendation not to recommend, but he was making no recommendation. And my understanding that he was not saying do not refer, he was making no recommendation. And that was my understanding when I said he did not deal with it. He made no recommendation regarding this matter.
Yes, but then look further at the paragraph Counsel Advocate Ngcukaitobi referred to. It's not only the analysis part at paragraph 45. Counsel referred to further parts of Dr. Brauton's opinion. For instance, if you look at LO 00170, he makes a conclusion there. And he says, in all the premises, it is respectfully submitted that the NDPP ought to consider making a submission to the President for the institution of an inquiry in terms of Section 12(6)(a) of the NPA Act against Advocate Chauke pertaining to his involvement with and handling of the Boyson's Kato Mena case.
That's
He
correct,
makes a
Chairperson.
conclusion there.
That's correct.
And it is that paragraph 68 that has to be read in the context of the earlier paragraphs, which were referred to you by Advocate Ngcukaitobi, shouldn't we?
Chairperson, my response to that is that my understanding was that he was making no recommendation with regard to the Mduli matter. He was not saying it should not be referred. Look, if you look at it with paragraph 45, that was my understanding, is that he was making no recommendation.
The point that I'm making is in relation to your earlier evidence at page 131, the transcript where you said Dr. Brauton's expressed no view.
That was my recollection, Chairperson, is that because my understanding was that he made no recommendation, I took that as not expressing a view. He made no recommendation. That was my understanding and how I interpreted it.
Yes, thank you.
Advocate Batohi, let's go back to paragraph 45.
Paragraph?
45, LO 00163.
I'm there.
Do you mind reading it aloud into the record?
Sure. In light of the findings in the SCA full decision as referred to above, no recommendation is made herein that a section 12(6)(a) inquiry be instituted against Advocate Chauke relating to his withdrawal decision in the Mduli case and referring the murder charge to an inquest instead.
There is no full stop after no recommendation.
That's correct.
It proceeds and said, no recommendation is made herein that a section 12(6)(a) inquiry be instituted.
That is correct.
So that is Dr. Brauton expressing his opinion that no recommendation should be made or no referral should be made to refer Advocate Chauke in relation to the Mduli matter. If you read that whole paragraph, because it's just one sentence.
That is not the way I read it.
You read it up to no recommendation and stopped there.
No, I didn't.
Okay. So what do you make about the next few words? Is made herein that a section 12.6a inquiry be instituted against Advocate Chauke relating to his withdrawal decision.
As I mentioned, my understanding of this is that he made no recommendation. It's not that he recommended that the matter not be referred.
Okay, I'll accept it. It's a matter of semantics. Thank you.
Thank you.
Yes, thank you, Advocate Batohi. The rest will be a matter for argument.
Thank you,
You
Chairperson.
may proceed, Counsel.
Thank you. Advocate Batohi, I will argue that you've lied in your evidence when you claimed that Dr. Brauton expressed no view. Dr. Brauton expressed a view. You've also lied in your evidence when you said Dr. Brauton did not deal with the Mduli matter. He dealt with it extensively. Could I move on to the...
No, I'd like to respond to that, please.
Yes, respond.
I was just writing it down so I get it right when I respond. Firstly, I've got no reason to lie in this matter. No doubt you'd probably find an argument that I do have a reason. But let me say that I did not lie when I tendered my evidence. My understanding of it, the way, in light of Dr. Brauton's the part that he deals with the Mduli matter, my understanding of it was he was making no recommendation in that matter. And that was my understanding. I'm not lying about that. And when I said in my affidavit, he did not deal with this matter, why would I lie about it when his supplementary affidavit, it's there for everyone to see that it is he addresses it in his affidavit. So why would I lie about that when a glance at his opinion would see that there is a portion that addresses the Mduli matter? So it's not a lie. It is my understanding about it. And the comment by counsel that it's dealt with extensively in his opinion is, in my view, not the correct one, because if you look at his entire opinion and annexures, the Mduli matter is dealt with, I would say I'm guessing, 1% of that opinion would be too much, but it's just in a few pages, and we have 2 lever arch files. So I want to really emphasize that I am not lying about this. I've got no reason to lie about it. That was my understanding.
To show your lie, when you answered the chairperson, until the cross-examination, those paragraphs pertinently addressing the Mduli matter were never brought to the attention of the panel by yourself.
Sorry, can you repeat that?
I'm saying to show your lies to this panel, those paragraphs were never brought to the attention of the panel by yourself until the cross-examination.
In my view, there's a lot in this document that I have not, otherwise I should have been given a few days to read out Dr. Brauton's opinion, all of them, the first one, the supplementary one, and to go through all of his evidence. I have just dealt with the key aspects of his evidence. But what is before this inquiry is all the reports, all the documents, and this is in fact what the inquiry has to look into, is whether all of that evidence supports that Advocate Chauke either conducted misconduct or is not fit to hold office. But it's not just those parts that I have referred to. It is the totality of all of the evidence.
Yes. Could I move on to the next topic? When we left on Monday, we had left a question around the origins of the terms of reference. You remember that?
I don't remember specifically, but I know we did deal with it.
Don't you remember that the chairperson had asked, how did the president get to those terms of reference? Were they recommended by you or were they not recommended by you? And you denied that you had recommended them. In fact, you said that the terms of reference that were concluded were different to the terms of reference that you submitted.
I did say they're different.
Yes. If I could ask you to go to file 3 again, starting at page 163.
Is that your file?
Yes, file 3, 163.
I'm there.
Now, this is a letter written by Advocate Lekgetho, who is part of the NPA team. One of the annexures that are submitted is Annexure L. Now, Annexure L is a draft letter to be signed by the president. And it's itself not signed. And I want to show you it at page, I must find it now. It's at page 181. Yes, it goes from page 181 to 183.
I see that.
Who gave the president this draft letter?
I did. I think it was the one that was attached to the bundle that was sent to the minister.
Yes, you gave the president this draft letter.
That's correct.
Now, if you then go to,
I beg your pardon, Council. Annexure L, is it that letter at 181, at page 181?
yes, Madam Chair, it is. Yes.
Should we then mark it in your bundle? That will be.
Yeah. Yes, Madam Chair, we've just put this as a cross-examination bundle.
It is sought to convey to the president what issues you had with Advocate Chauke, as you have just mentioned. I just want to check.
Can we look at the draft letter again,
No.
Chairperson?
I'm referring to your answer that you have just given now.
Yes, I answered it, but when I realize it's being scrutinized to the level it is, I'd like to look at the letter.
No, Council. I'm asking you. You responded just maybe a minute ago that the draft letter sought to convey to the president what issues you had with Advocate Chauke. That was your response.
Chairperson,
Because I want to ask you a question on that statement.
well, I would like to look at the letter first.
No. Did you answer to Council his last question when I interrupted him, that you answered your draft letter to the president was to convey the issues you had with Advocate Chauke?
Chairperson, that was loosely put. That is why I'm asking that I refer to the letter. There may have been other things there that I added, and I think in fairness, I should be allowed to look at the letter and then say exactly. I loosely put it. I didn't refer to it because we've been through some of it and we've compared it with the terms of reference, and it relates certainly to some of the conduct that we had an issue with, but there are other things in the letter as well.
No, I'm not talking about the contents of the letter. I'm asking you a question based on your answer to Advocate Ngcukaitobi, that Your draft to the president was to convey the issues that you had with Advocate Chauke. That was your answer, correct?
Chairperson, we sent a whole bundle of documents to the president.
No, Counsel. And I'm going to ask you again for the last time. When you responded to Advocate Ngcukaitobi a short while ago, you said your draft letter to the president sought to convey to him the issues that you had with Advocate Chauke. The words, to convey the issues you had with Advocate Chauke. Is that what you said?
That's what I said, loosely.
Yes, thank you.
Yes. In fact, on this topic, the suspension letter of Advocate Chauke is identical to the draft that you prepared. I don't need to go through it, but we
That's
can
fine.
accept that.
Sure.
Yes. Now, I wanted to just come back to trying to understand what is the substance of your answer. There is a document headed the Presidency Draft Terms of Reference at page 177 of File 3.
What page is that?
177, Madam Chair.
177.
Yes. Now,
And what is the question with regard to that?
yes, thank you. If you could go to page 179. What this document does is to identify the issues to be decided.
What is this? I'm sorry.
Yes.
For the purpose of the record, what is this document
Well,
at page 177?
I'm very happy, Madam Chair, you've asked that question because it's one of the documents we received from Advocate Lekgetho. And I was going to ask the witness to explain what is the status of this document.
At 177.
At 177, yes.
Yes, thank you.
Yes. Advocate Batohi, if we could just go to 179. This document purports to identify the issues to be determined by the inquiry. At Roman figure 1 and Roman figure 2, in broad and generic terms, but does not identify any terms of reference in the same detailed sense that the gazetted terms of reference do. Now, who prepared this document at page 177?
So this is the draft terms of reference that I was referring to earlier, Chairperson. It was prepared by my office.
Was this a first draft, a final draft?
I can't recall. I assume it would have been the final draft.
And what happened to it? You gave it to the minister?
Well, I thought it would have been sent to the minister because that's why we drafted it. But I'm not sure.
Yes. In any event, the point I'm really trying to understand here is it's only at page 179 where there is an identification of the issues to be decided. But there are no actual terms of reference in that document at all.
The heading of the document is draft terms of reference.
Of course.
And in fact, there's nothing wrong with having broad terms of reference.
Now, what I'm asking you is there are no terms of reference in the document. There is an identification of the issues to be decided at page 179.
This is a draft terms of reference document. We can quibble about semantics, but this is the draft terms of reference. And at page 179, as you say, the issues are broadly defined.
Yes. The only document that specifies the complaints against Mr. Chauke to the level of the terms of reference is what we were looking at page 181.
That's the letter to the president and not the
Indeed.
draft terms of reference. that
Indeed,
was drafted.
yes.
That's correct.
And that's what ultimately makes it as terms of reference by the president.
That was
Page 181.
That's the president's decision.
Yes. Thank you. Now, in relation to that final document and your own draft, you've never identified the issue of Mr. Chauke acting in excess of his authority as part and parcel of that letter at page 181.
Chairperson, I'll have to look at this carefully. Because that's not what I said. And when the questions are too long, I'm not able
All
to
right,
respond
answer it
to
then.
things, and then it gets
All right.
confusing towards the end.
Answer it.
So firstly, I didn't say there were no case dockets. I said there was no, to my knowledge, there was no racketeering case dockets.
Yes.
That was my answer. I did not say there were no case dockets.
I understand.
Because we know for a fact that there were 23
Yes.
murder dockets.
No, we are talking about the racketeering case docket.
So I think that should be made clear. I did say there was no racketeering case docket, to my understanding.
Yes. Well, this is the point I'm making to you. You said the entire charge, 3.1.1, is about racketeering.
Can you repeat that?
You said the entire charge in relation to 3.1.1 is about racketeering. That's the only case docket we are talking about.
So when I said it relates, I didn't say the entire charge. You know, we must look at the record and see what words I use, because they're being put to me as me saying the entire charge. What I meant is that the charge that we were referring to was racketeering.
Yes.
That's correct.
But that's the only charge that you have an issue with under 3.1.1.1 until 3.1.1.5.
That is correct. We're dealing with the
Yes.
racketeering.
Yes. Now, we come back then to the reference to case dockets comes from your own draft at A.
That's correct.
Yes. Now, can we then move on to
Can I explain that before we move on?
Yes.
I would like to explain it, because we leave things hanging and then there's no explanation for it. Chairperson, the reference to the case dockets there were 23 murder case dockets. And that is the reference to what this is saying is that he was not provided with those case dockets. Now, those case dockets could potentially or would potentially be the basis for predicate offenses in any racketeering charge. So it would have been important for a DPP to have all of that if he is required to sign an indictment for a racketeering charge. So that was the context, or what I would have said at the time with regard to case dockets.
Yes. Could I then move on to item B? Now, if you remove the first words in the Boyce and Ngcukaitobi matter, you start with recommended. Now, I didn't see any difference of substance there. So you can compare it yourself and tell
I'll do
me.
that now. That's correct. It's the same.
Yes. If you look at C, if you compare that with 3.1.1.3, again, just remove the words in relation to the Boyce matter, starts with sought to defend. Again, I didn't see anything different there.
That's correct. It's the same.
If you look at D, let's do the same exercise and compare it with 3.1.1.4.
That's correct. It is the same.
Then the last of the racketeering charges is E compared to 3.1.1.5, starting with the words attempted. Again, I saw nothing different there of any substance.
That's correct.
Yes. Now, the matter of Lieutenant General Mduli is worded slightly differently. The 3.1.2 starts with the words, the failure to continue with the charges against Lieutenant General Richard Mduli for his involvement in the murder of Mr. Tefo Abel Ramokhibe. Those words do not appear in your draft. Is that correct?
That's correct.
Yes. But the critical part starts with caused, and it comes directly from your own paragraph F. Compare those words caused, starting with where it says Advocate Chauke caused at 3.1.2, and at F, look at after the Mduli matter caused, and tell me if there is any difference.
It's the same.
Yes. Now this is the whole point why we asked for the draft that you sent to the president. What we can now see is that these terms of reference are virtually identical to what you gave the president, except for item A, which we discussed. And yet you've given evidence that seeks to distance yourself from your own terms of reference. Can you explain yourself?
Yes, I'm not seeking to distance myself from my own terms of reference. When I said that these final terms of reference were different to the terms of reference, the draft that we had submitted, Chairperson, I was not comparing it with this. This is not a terms of reference. The document that Council is referring to is a draft letter to the President, and I accept that we've gone through this exercise. I was referring to a draft terms of reference, which I understood that we sent to the President's office separately from this letter. Now, I have seen a draft of that document, but my office was trying to find the precise one that was sent to the President. And that is the document that I was referring to when I said that it was different from these terms of reference. I was not comparing this final terms of reference with the draft letter to the President. In fact, I've not even, but for when this letter went, I've not even looked at this letter in preparation for this inquiry, because I've just had no time to look at all of these documents. But to be clear, when I said it was different, I was not referring to the draft letter of the President. I was referring to a draft terms of reference, which we also submitted, is my understanding, to the Minister.
So the problem, Advocate Batohi, even this document we've now gone through painstakingly was never disclosed by you. It came up in the cross-examination.
So, Chairperson, again, I want to be very clear. There's nothing we want to hide in this matter. These documents are all referred to in the document that was sent to the Minister. They all attach as annexures to my SB 10. They are annexures A to M, which are referred to well, it should be referred to. Let me just get to SB 10 before I start saying things that are not absolutely accurate, because I do want to be accurate in the circumstances, as accurate as I can be. I'm looking at SB 10. It goes to Annexure F, J, K. What's the last one? J. K is on 175. Annexure K, L, and M. So SB 10 refers by name to every one of these documents that was submitted in the bundle. We are not withholding anything, Chairperson. It was just that my affidavit would have been extremely long if we attached everything to my affidavit. So what we did is we referred to them and didn't attach them. But it's not withholding evidence, Chairperson. It's all in my affidavit.
You see, the problem even with that answer is that if you are going to give evidence to this panel that the president has given you terms of reference that are different to what you submitted, you have an obligation to disclose to the panel that you also gave them Annexure L.
It's in my affidavit that I gave them Annexure L, so I'm not withholding it. It's SB 10, refers to Annexure L.
Just one, concern. And it's a concern that I have raised even in the past about non-provision of documents in advance. This SB 10 that you are now talking about.
Pardon me?
I say this SB 10 that you are now talking about is part of the documents that came late to the inquiry.
No, it's
the annexures. I'm still talking. The annexures, I think, as lawyers generally, and even as human beings, we understand that it is very important that if you give me a document that makes reference to annexures, those annexures must be part of the document. The reason that you deem it fit to see it as an annexure to the document, it means it's an important document. So here we are today, we get these documents that we are told are just coming to surface to the inquiry for the first time today. Thank you. Is it soft? I'm told for a change, my voice is very soft. Okay.
I'm struggling as well. That's why I've been asking.
Okay. Maybe there's something wrong with me. Sorry about that. I beg your pardon. Ordinarily, I'm told I scream. So I try to be a ladylike and talk softly. It doesn't help. Okay. You understand my concern?
I do.
Okay. Thank you.
Can I respond?
Yes, you may.
Thank you. So I did tell my team, we did say that we must look at my affidavit and make sure that all the annexures are uploaded. And I would have expected that all of these documents that are annexures to my annexures would have also been uploaded. So to the extent that they have not been, and I need to confirm with the team, I will apologize for that, but that was an exercise that they were meant to go through meticulously to make sure that every annexure to an annexure is uploaded. So I will check with them and see what the position is. And I would have thought that that would have been done by now.
Yeah, I don't want to belabor the point. I've just been tempted to reiterate this concern now. Thank you.
No, thank you, Chairperson.
Yes. Advocate Batohi, I'm sorry I'm not done on this point.
It's fine.
Because your claim that Annexure L was attached to SB 10 is a lie. If you go to SB 10 275, page 275, paragraph 31. And that's your letter of the 18th of August, 2023. It says, it is further recommended that Advocate Chauke be afforded an opportunity by the President to advance reasons as to why he should not be suspended and a fitness inquiry be instituted against him. A draft letter is attached hereto as Annexure L. Annexure L itself was never there.
I think it is important for the record to make mention of the fact that SB 10 forms part of Advocate Batohi's affidavit.
Yes, indeed. Thank you, Madam Chair. So if you, Annexure SB 10, which is
It is SB 10 266.
yes, SB 10 266, yes, that's where the document starts. And the specific paragraph I'm referring to is paragraph 31, which is at SB 10 275. What I'm asking you, Advocate Batohi, is that your statement that Annexure L was included in SB 10 is a lie, because Annexure L was never attached to SB 10.
Before Advocate Batohi answers, which paragraph did you refer to?
Paragraph 31, Madam Chair, at page SB 10 275.
Chairperson, can Council please repeat that? Because I want to be clear about what it is it's alleged that I'm lying about.
When you say, I said to you, you failed to disclose Annexure L. Then you said, I did not fail. It is part of SB 10. And I've now gone back to SB 10, particularly at paragraph 31.
Mm-hmm.
What is stated there is that it is further recommended that Advocate Chauke be afforded an opportunity by the President to advance reasons as to why he should not be suspended and a fitness inquiry be instituted against him. A draft letter attached hereto as Annexure L. Annexure L was never attached to SB 10.
That is correct. Well, let me rephrase that before I answer that quickly. SB 10 is a letter to the President. Let me get that right. Is a memo to the Minister. And those annexures that you're referring to are annexures to the memorandum to the Minister. These would have been attached to the memorandum to the Minister, but they were not attached to my affidavit. So when the attachments to my affidavits were put together, the memorandum only was attached, not the annexures. But my point was that if one reads the memo itself, it refers to all of these annexures and gives a description of them. Let me just make sure that I am clear about that, because I am, just a moment, Chairperson, if you give me a moment. I just want to make sure that I am, I'm going to look at Annexure L now so that I am clear. Annexure L is in the bundle provided by Advocate Chauke's team. If I could just be helped with the page number, will be useful.
I beg your pardon.
What page?
Let me correct that. Annexure L
Mm-hmm.
forms part of the documents that were referred to or put together by your junior counsel, Advocate Ngcukaitobi,
That's correct.
in a document that was emailed to Katleho Aubrey and to yourself, among other people.
That's correct,
who
Chairperson.
are mentioned in that email. So it is not correct that is provided by the team of Advocate Chauke. It was provided by your office, if I may put it that way. And that consists of the list of those documents at page 163.
Chairperson, I am not incorrect when I say it was provided by them. I meant it was provided in this big file. This is the file that I received from them. So that is what I meant. But you are correct indeed that this is something that came from my office and was sent to them by email.
And Advocate Lekgetho copied you that email,
Yes, that's correct.
so you had the document.
Yes, I'm not disputing that.
I'm just correcting the fact that it was provided by Advocate Chauke's team.
Chairperson, I'm saying I did not, what I meant when I said that is that this entire bundle in this black file has been given to me by Advocate Chauke's team. And it's in this bundle. That's all I meant. But of course, it comes from my office.
The source
Yes,
is your
absolutely.
office.
But they handed me this bundle. That's what I meant when I said they gave it to
It
me.
is very important to get it right because we will get confused when we write the report.
Certainly, Chairperson, I will be mindful of that. So let me look at Annexure K. I'm going to try to, if anyone can guide me to the page, it will be quicker so that I can read this document.
Sorry, Advocate Ngcukaitobi, I interrupted.
Yes.
You had referred Advocate Batohi to
Paragraph 31, which is,
paragraph 31.
yes, simply to ask her, and I think she has done that, to confirm that that Annexure L was not part of SB 10.
Let me correct that, Chairperson. It was not attached to SB 10 in my affidavit, but it was certainly part of the memorandum that was submitted to the minister when it was submitted. But as I've been painfully trying to explain, we did not add all the annexures when we did my affidavit, and they have been now supplied to council, to Advocate Chauke's team.
Advocate Batohi, can I ask you, on your main defense on this issue, which is that this was a draft letter that you prepared for the president to sign when suspending Advocate Chauke, and you did not expect that these would be the terms of reference. Now, it is a bit of a puzzling expectation on your part. Why did you not expect them to be part of the terms of reference when you've given them to the president?
My understanding is that we submitted a draft, but I could be mistaken about that. But this was a letter to the president, and I didn't know what in fact, it was a draft. The president is at liberty to change that letter as he deems fit. We did not expect that this will find its way into the terms of reference.
So there you have it. Let me break down what just happened here because this is serious. Ngcukaitobi just exposed Batohi on 3 major lies. First, she claimed Dr. Brauton never gave an opinion on the Mduli matter. That's a lie. The man wrote extensively about it. Second, she said Brauton didn't deal with the Mduli case. Another lie. He dealt with it in detail. Third, she conveniently forgot to include critical documents like Annexure L. How convenient. And you heard her defense? Why would I lie when the documents are there for everyone to see? Well, Shamila, that's exactly the question we're all asking. Why did you lie when we can all read the same documents? The woman tried to play word games, talking about semantics and interpretations. But Ngcukaitobi wasn't having it. He shut down every excuse, every explanation, every attempt to wiggle out. And here's what makes this worse. This is the National Director of Public Prosecutions. This is the person who decides who gets prosecuted and who walks free in South Africa. And she's sitting there being accused of lying under oath at a commission. Now, you understand why cases like Mduli never went anywhere. You understand why people like Ngcukaitobi and others were protected. Because the person at the top was playing games with the truth. This woman has been caught. The evidence is there. The lies are exposed. And Ngcukaitobi made sure everyone in that room including the commissioners, saw exactly what she did. So the question now is, what will the commissioners do with this? Will they call it what it is, perjury? Or will they say it's just a matter of interpretation? We'll be watching. If you enjoyed this breakdown, make sure you're subscribed, because Batohi's problems are far from over. There's more coming. Hit that like button, share this video, and let's keep exposing the truth. I'm out.